Thanks a lot. It strikes me that this is a huge issue affecting major multinational corporations who have quite an interest in what we do here and the interests of workers. I was struck by what Dr. Altmaier said about, we're the third country in terms of the number of EWCs here. I wonder if Dr. Altmaier could put a figure, it'll obviously be an estimate, of how many workers roughly would be included and would be affected by our rules and our legislation then.
Oh, that's a big issue. There are no reliable figures on the number of companies, and you cannot say how much people are involved. There are European Works Councils representing about 2,000, 3,000, 4,000 workers, and others represent 20,000. And when you look to large corporations like Airbus or big automotive companies, they represent 100,000. So it's in between all those figures.
It will be in the millions, probably.
Maybe.
Yeah. Okay.
I have no clear figures.
Yeah.
But it will be a huge amount of workers.
Yeah. I mean, if you're thinking of between 140 to 180 companies with thousands, tens of thousands, or hundreds of thousands of workers, it is a very, very large group of workers who are affected. Secondly, just to turn to Mr. Sack, I mean, you didn't mince your words in terms of our compliance with the directive. In your opinion, there's just no way that we're in compliance with this directive, is that
correct?
And would Mr. Lavelle or Dr. Lavelle and Dr. Altmaier agree with that or disagree with that?
No, that seems to be from my reading of it.
Yeah. Thanks.
Sorry, I did not catch the question.
Whether you agree that Ireland is in breach of the directive?
Yes, I think so.
Yeah. Thank you very much. Next, just it strikes me, I obviously agree that the issue of extending the remit of the WRC is a route for this, but it does seem to me that isn't the only issue, that this is about access to justice, which relates to the question of means, which Dr. Altmaier was making the point there, that does seem to me to be like a central part of the legislation that we will need to write, or the government will need to write, is that it's going to have to provide for means, because you have a David and Goliath situation here. You have some of the biggest corporations in the world with effectively unlimited access to resources, and on the other hand, EWCs that have no mechanism of raising resources for themselves. They can only have what is provided by the companies. So would you agree that, maybe Mr. Sack, that it is essential that there's an obligation in the legislation for companies to provide for experts, legal advice, and so on?
On that specific question, yes, I would agree that there's an obligation. There should be an obligation, a legal obligation, to do so, because it is absolutely impossible, as I think others have made clear, especially Dr. Altmaier. EWC members cannot be expected to bring complex legal disputes in the Irish jurisdiction on their own. In their non-native English language, in an unfamiliar legal environment, potentially up against very well-paid lawyers and barristers. There is already a requirement in the legislation. It comes from the directive, and it appears in all legislation implementing the directive. It's actually in section 17(1)(a) of the TICE Act, and that is requiring the central management to provide members of an EWC with the means required to apply the rights arising from the directive to represent the collective interests of employees. So that's already in there. And so really the question is, does that include the cost of advice, support, help, whether that's legal advice or just expert advice, like Dr. Altmaier, to bring a dispute on behalf of an EWC? And I think we await a test case. This is one of the issues that goes to adjudication at the WRC. So we await a test case as to whether that is what it means in the Irish context. Just to say, in the UK, it was ruled that yes, it does cover legal costs.
Yeah. Well, if you might, while we're on that, if you might deal with the talk to us a little bit about the CAC, about what kind of cases it dealt with, how it dealt with them, whether there's things that we can learn there.
Yes, I brought probably 10 or a dozen cases to the CAC on behalf of European Works Councils. We've found the procedure very useful in that it's easy to understand, it's quick, you can get decisions within a matter of weeks. They also offer voluntary sort of mediation, if you like, on an informal basis. So the general practice is, before going to a formal hearing to resolve the dispute, to have an informal meeting or several meetings to see if it's possible to resolve it informally. And of course that's also possible through the Labour Court, I believe, and the WRC. And that's a very helpful procedure, and we've been able to withdraw some of the complaints through voluntary agreement. But, you know, it's a civil proceeding with that standard of test, and the complainant can make their own case for them and given a fair hearing, and it's worked well in the UK.
Thanks. And one of the suggestions for a remedy that you make as a possibility is to use the 2006 Information and Consultation Act. How do we know that that will work? Do you know how many cases have been taken to the WRC about these sort of issues under this Act? How have they gone? What has been the outcome of them?
I'm sorry, I don't know the answer to that question, other than I believe there's been rather few.
Yeah, I think it's 6, but perhaps. And what, has that worked well for those who have taken the cases, or no?
I don't know,
I'm not sure.
Okay.
Yeah, I'm not sure.
Okay, I mean, there's a certain view that that Act is weak, that it was watered down through a process of corporate lobbying when it came into effect. So.
But I think that's other issues in the legislation rather than the enforcement per se. Yeah, you know, I mean, I was in the UK negotiating that directive on behalf of the UK government. We worked very closely with the Irish government, which is why the legislation looks rather similar. And we were trying to limit its impact in the two countries, yes. But it's not to do with enforcement as such.
Okay. Just one final question, if I may, is how can we ensure that any dispute mechanism allows an entire EWC to take a dispute and not just an individual member?
I mean, this would normally be simply through the wording of the legislation. I mean, sometimes the legislation will say a member can, in other places it will say the European Works Council can, and then in which case it's down to the internal rules of the EWC as to how they take a decision to do so. I believe that currently, in terms of arbitration, is it the European Works Council as a whole that brings the dispute? It just says the parties, I think, doesn't it? It's really just how you word the legislation, yeah.
That's the other, when we talked about the means, we talked about, we kind of focus a little bit more on the financial means, but there's obviously the statutory means as well. So that gets to your question as well. So I think there's a lot of debate around now as well, and again, a lot of variability across member states in terms of how it's worded, and whether, you know, European Works Councils can take those cases on their own. So again, that goes back to the bigger issue of means, both statutory means and financial means.
Thanks a lot.